In 2015, the Supreme Court of India delivered one of the most important constitutional judgments on online freedom of speech in modern India. That landmark judgment was Shreya Singhal versus Union of India. Today, many constitutional observers believe that similar free speech questions may once again arise in the ongoing controversy surrounding the so-called Cockroach Janata Party or CJP. The central constitutional question is: can online satire, memes, political criticism, and digital protest be restricted merely because they become uncomfortable, embarrassing, controversial, or institutionally inconvenient? Friends, welcome to your YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. I am happy that our channel has completed 1 lakh subscribers and has received the YouTube Silver Creator Award. Thank you for your continuous support. For more legal awareness videos, subscribe to the channel free of cost. You may also support the channel by taking a membership of 59 rupees or 119 rupees through the GPay QR code displayed on the screen. Thank you for your continued trust and support. Now let us move to today's main issue and understand what exactly the so-called Cockroach Janata Party controversy is, how it reportedly originated, how the matter reached the Delhi High Court and the Supreme Court, and how major constitutional and legal questions relating to free speech, Article 19, 1A, Section 69A, Judicial Dignity, online satire, and digital protest emerged from this entire controversy. Who is Shreya Singhal? Shreya Singhal is an Indian advocate and constitutional rights campaigner who became widely recognized for challenging Section 66A of the Information Technology Act before the Supreme Court of India. In 2012, while still a law student, she approached the Supreme Court questioning the constitutional validity of Section 66A, a provision that allowed arrests for certain forms of online speech. Her petition ultimately resulted in the historic 2015 judgment in which the Supreme Court struck down Section 66A as unconstitutional and violative of freedom of speech and expression. Shreya Singhal belongs to a distinguished legal family with a long association with the Indian legal and public system. Her family includes Justice Sunanda Bhandare, former judge of the Delhi High Court, MC Bhandare, senior advocate, former member of parliament, and former governor of Odisha, and H.R. Gokhale, who earlier served as the Union Law Minister of India. What was the Shreya Singhal case? The Shreya Singhal case challenged Section 66A of the Information Technology Act, 2000. That provision criminalized online messages considered grossly offensive, annoying, or causing inconvenience. The controversy began after 2 young women from Palghar, Maharashtra, were arrested over a Facebook post and a like following the death of Bal Thackeray. Disturbed by the incident, Shreya Singhal approached the Supreme Court under Article 32 of the Constitution. On 24 March 2015, the Supreme Court struck down Section 66A entirely as unconstitutional. The court held that vague restrictions on online speech violate Article 19, 1A, which guarantees freedom of speech and expression. Most importantly, the court laid down a historic constitutional distinction. Discussion is protected speech. Advocacy is protected speech. Criticism is protected speech. Satire is also protected speech, subject to reasonable restrictions under Article 19, 2 of the Constitution. However, incitement, violence, public disorder, and speech falling within the constitutional restrictions under Article 19, 2 may be restricted by law. The court clarified that mere discussion or advocacy, however unpopular, remains constitutionally protected unless it reaches the level of incitement. The judgment also recognized the chilling effect doctrine, meaning vague laws or excessive state action may discourage citizens from speaking freely online. That decision became a foundational judgment concerning digital free speech and internet rights in India. Constitutional connection with the present CJP controversy. Although the present Cockroach Janata Party controversy is not a direct Section 66A case, an important constitutional connection still exists between the two matters. The connection relates to issues such as online freedom of speech, social media expression, digital protest, political satire. meme culture, and restrictions on internet-based expression. In the Shreya Singhal judgment, the Supreme Court clarified that discussion, advocacy, criticism, and satire remain constitutionally protected unless they cross into incitement, violence, or other restrictions permitted under Article 19(2). Therefore, an important constitutional question now arises in the present controversy. Can satire, criticism, memes, and digital protest on social media be restricted merely because they are uncomfortable, controversial, or politically inconvenient? Further, since issues such as blocking of social media accounts and online restrictions have reportedly emerged in the CJP matter, Section 69A of the Information Technology Act, which deals with blocking powers, may also become legally significant. Thus, although the CJP controversy is not directly connected with Section 66A, the constitutional principles laid down in the Shreya Singhal judgment regarding online free speech, chilling effect, digital dissent, and constitutional protection of internet expression may become highly relevant in understanding the present controversy. Now comes the Cockroach Janata Party controversy. Recently, the so-called Cockroach Janata Party became viral across social media through memes, satire, symbolic protest, and online political commentary. Reports suggest the controversy emerged after oral courtroom remarks involving references to cockroaches and parasites circulated widely online. Soon, social media campaigns expanded rapidly. Online accounts reportedly gained large followings. And legal controversies reached both the Delhi High Court and the Supreme Court. Delhi High Court proceedings. According to media reports, Abhijit Deepke approached the Delhi High Court challenging blocking of the CJP X account. The reported issues involve online censorship, account blocking, and freedom of digital expression. This directly raises constitutional questions under Article 19(1)(a) PIL before the Supreme Court. At the same time, PILs were reportedly filed before the Supreme Court seeking investigation into alleged fake advocates, alleged commercialization of courtroom remarks, and misuse of judicial observations for branding or monetized digital circulation. Reports further indicate that the Supreme Court declined urgent listing while orally observing. Don't take it so sentimentally. Although oral observations are not binding judicial precedent, the remark became widely discussed in legal and media circles. So how does Shreya Singhal support CJP free speech arguments? This is where the constitutional connection becomes important. In Shreya Singhal, the Supreme Court strongly protected online speech, democratic dissent, criticism, advocacy, and internet expression. Therefore, supporters of digital free speech may argue that mere satire, memes, ridicule, criticism, or political embarrassment cannot automatically become grounds for suppression. They may further argue that blocking accounts, vague restrictions, or disproportionate censorship can create a chilling effect on democratic speech. And this principle directly emerges from the reasoning in Shreya Singhal. But free speech is not absolute. At the same time, Article 19(2) of the Constitution permits reasonable restrictions concerning defamation, contempt of court, incitement, public order, sovereignty and integrity of India, and security of the state. Therefore, opposing parties may argue misuse of judicial remarks, distortion of court proceedings, commercial exploitation, or organized misinformation. Ultimately, courts may have to decide: is this protected political satire and digital dissent? Or has the conduct crossed constitutional limits recognized under Article 19(2)? Why these cases may become important? The ongoing CJP matters may become significant for the future of internet freedom, online satire, meme politics, digital protest, and constitutional free speech in India. In many ways, the controversy appears to revisit constitutional questions first addressed in Shreya Singhal vs. Union of India. Conclusion. The Shreya Singhal judgment established a powerful constitutional principle. Democracy protects dissent, criticism, satire, and unpopular opinions unless they cross into unlawful incitement or other constitutionally permitted restrictions. Now, the Delhi High Court proceedings and PILs before the Supreme Court involving the Cockroach Janata Party may test how those constitutional principles apply in the era of viral memes, digital movements, and social media-driven political protest. The eventual judicial outcome may significantly influence the future of online free speech jurisprudence in India. Thank you for watching this video. If you found this information useful, please like the video, subscribe free of cost, and share your views in the comments. For more legal insights, do not forget to press the bell icon. I shall meet you again soon in the next video. Jai Hind! Jai Bharat!